I am going to teach you this is me, and new lecture from my house, and it is to tell you about myself. um, my name is Sushil, and this is my channel. My name is Sushil. My name is Sushil Kumar Misra, and I will tell you about fundamental rights. So fundamental rights are important section in our on our UPSC paper. So in two videos, earlier two videos in fundamental right in Blackboard format, I have tell you about these things. So just uh, go through with those with those videos, and then continue it. Okay, now what is the feature of the Indian Constitution? So what is the features of fundamental rights? So there any problem to write fundamental right as a FR? No, this is a E for stand for funda and R for stand for fundamental rights. Okay. Now, so into earlier I have told you this is a availability के point of view से होता है availability of the FR and second availability in a sense किसको मिलेगा और किसको नहीं मिलेगा. तो one point you will citizen they are not citizen but temporarily they are living in our country. So whether they should have a fundamental right or not, certainly some rights they should have, and some rights they don't access. Second point is our absolute or qualified. Some articles are qualified, and these fundamental rights are not absolute. First, let me tell you, let me make it very clear. This article, fundamental right 12 to 35, article 12 to 35. This is not a absolute. That means there is always a restriction associated with these rights, and these restrictions have been given in Constitution, and Supreme Court is the sole guardian to decide what kind of Supreme Court of India is the sole guarantor of the Indian Constitution and this fundamental right. So only Supreme Court can tell you this. You have this specific domain. जैसे आपको किसी को गाली दे रहे हैं, अगर सुप्रीम कोर्ट के नहीं आपको गाली देने का अधिकार है, इट्स कम्स इन राइट टू लाइफ और फ्रीडम ऑफ स्पीच एक्सप्रेशन, देन ओके, अदरवाइज नहीं. सो सुप्रीम कोर्ट के लिए इसका होना ज़रूरी है. तो सुप्रीम कोर्ट जब कह देगा तभी आप इसको यूज़ कर पाएंगे. ओके. सो फर्स्ट आई हैव टू अवेलेबिलिटी ऑफ द फंडामेंटल राइट. नाउ दिस इज योर सेकेंड. नाउ थर्ड पॉइंट आई विल टेल यू. थर्ड पॉइंट थर्ड पॉइंट इज ओके. तो अब हम आगे बताते हैं कि व्हाट इज द arbitrary action of the state and against individual private. So some of the fundamental rights are available against the state. It is very much written in the constitution itself. It is article, so much article, so much so condition the state can do so thing and the state cannot do such thing. They can breach a fundamental right, they can't breach a fundamental right. So much so conditions which I am telling you. So much so condition, this is the important term in the constitution. Second thing, some of the article which are against the say some of article which are against the say State cannot do such thing, but a private individual. Let me make you very much clear what is state. State is not like a UP state or MP state, Bihar state. This is not 28, 29 state. Uh, that is not a state. A state has been defined in the constitution in article itself. So when the part 30 start, first of all, Dr. Ambedkar has defined what is a state. State may be a single company, state may be a private individual, state may be an institution, state may be anything. State means here state is a political notion. Anything which have a power, that is state. So don't confuse with the state with your this geographical state or political state. That is state is different. This state here, this state which right now I am telling you. So this state is different, and then that state is different. Okay. Now some are very negative character. Let me just change the color font. Some are negative in character. So if you go through the with article like 19 or 18 or 17, have you fundamental book? So the statement or the verbatim of that article tells state cannot do away, yeah, nothing with a standing state or nothing with a standing that. So they have negatively proved कि you cannot do such thing, 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 you cannot do such thing. This is means state cannot do, individual cannot do, high court cannot do, supreme court cannot do. Some article can some are defined in such a way. Now this is justiciable or non-justiciable. This was again a good thing. So first of all, let me tell you, fundamental rights are justiciable. Justiciable means you can go to the court through writ petition. Through writ, writ are of four types. So what is writ? Writ has four types: habeas corpus, mundamus, certiorari, and four. Certiorari, mundamus, and your habeas corpus. Habeas corpus. This is a thing. So you can go to Supreme Court have these four writs. चौथा मुझे नाम नहीं याद आ रहा है तो I'm not telling. Just go through Lakshmikanta, DD Vasu, or NCRT. You will find. So you can, if your fundamental right has been appraised, you can go to the Supreme Court or High Court through these writs, and Supreme Court will provide your remedy for that. Now justiciable, non-justiciable. Now some if this article, so we can understand, we can also, a question can come in the mind whether these articles are permanent or sacrosanct. Sacrosanct means very fixed. To these article, fundamental rights are permanent? No. Fundamental rights are not permanent. No. These are not permanent. Constitution has provided Parliament a power to amend the fundamental right, but here is a but basic feature of the constitution should not alter. So basic feature which was not originally written in the constitution, but it was a judicial invention. What I say, it a judicial invention. It a judicial invention. So basic feature of the constitution, Supreme Court in 11 cases or 5 or 9 constitutional judge they have defined some basic feature, and in parliament, even parliament cannot do such rights. What must they can amend the constitution partly or mostly, but basic feature of the constitution should remain. So sub article. So is a right, earlier there was article, there were 7 articles. I have earlier told you, right, to equality, religion, expression, freedom of speech, expression, religion, cultural rights, and education right. There are 7 type of right, but one right has been deducted. So now we have only 6 right, and one right to property is now it is a legal right. Now it is a legal right. So right to property, right to property is a legal right right now. Right to property is there, it is a legal right. So right to property is not a legal right. Okay, stop.